Good morning, good afternoon, good evening to all our participants joining from various parts of the world, and welcome to another session of the Bias Arbitration Week. We are joined here by an all-star panel to discuss a very interesting topic, concurrent delays in Indian law relating to arising out of construction projects in India. I would like to introduce our participants and panelists today. And foremost, I would like to thank all of them for joining us and providing us with their inputs on concurrent delay in Indian law. First and foremost, I would like to introduce Justice Arjun Kumar Sikri. Justice Sikri is somebody who really does not require much of an introduction. He is a retired judge from the Supreme Court of India and currently acts as an arbitrator for many arbitral tribunals arising out of various contracts in various sectors. Justice Sikri did his BCom honors from University of Delhi and has done 2 postgraduate diplomas from ILI, getting rank 1 in both of them. He even topped his LLB from Delhi Law Faculty in 1977.
Adarsh, I think you need not say all this. Don't bother. It is not occasion. Please, skip all this.
You're right, Justice Sikri. But most importantly, he was a lawyer, and before he was elevated to the Delhi High Court, he was a senior advocate designated by the Delhi High Court, and he was also the acting Chief Justice in 2011. He was the Chief Justice of the Punjab Haryana High Court, and before he was appointed as the judge of the Supreme Court. And finally, he superannuated in March 2019 as the senior most appointed judge. Now, Justice Sikri has authored over 4,700 judgments in different fields of law. He is currently a judge of the Singapore International Commercial Court, the chairperson of the Committee for Formulating an Action Plan for Online Dispute Resolution under Niti Aayog. And he's also the visiting professor of various law universities. Thank you, Justice Sikri. Thank you for joining us today. Next, we have Mr. Rohit Singhal. He is the CEO of Masin Projects. We just saw a very delightful presentation, a video presentation of Masin Projects. He is the CEO, and he's one of the leading international construction expert witnesses. He has over 25 years of international experience involving construction contract disputes, expert testimony, and project management. And Mr. Singhal has been appointed as an expert witness more than 50 times on delay, technical, and quantum matters. Recently, he was awarded the Outstanding Expert of the Year Award 2019 by the International Arbitrators and Experts in Engineering Sector, UAE. Thank you, Mr. Singhal, for organizing this and for providing us with your valuable views. We also are joined by Mr. Gopal Jain, Senior Advocate of the Supreme Court of India. He is a designated Senior Advocate of the Supreme Court with 25 years of experience in arbitration and commercial litigation. He has represented Indian and multinational clients in several complex and contentious commercial disputes. His areas of practice involve commercial arbitration, infrastructure, and regulatory disputes. And he has also advised several telecom and cellular services companies and represented PSUs such as ONGC, GAIL, MMTC, the Delhi Metro Corporation, and the National High Speed Rail Corporation in India. We have 2 more guests, Mr. Lakshmanan and Ramaiah. He is the head of the contracts administration of Larsen & Toubro. He has a unique distinction of being a civil engineer and a lawyer. He's heading the contracts and risk management for a company that is executing more than 40 projects involving more than 92,000 crore rupees. He's also involved extensively in resolution of contractual issues by way of other dispute resolution mechanisms like mediation, negotiation, and he has several anecdotes from his interactions with the leading individuals of the construction sector, and we are eagerly waiting to hear more from him. Lastly, Mr. Shourav Lahiri. He is a barrister of Atkin Chambers of the United Kingdom. He is a specialist in the construction and international arbitration sector. He has over 20 years of experience and has represented clients from all across the GCC, India, Southeast and East Asia. He has done several arbitrations in the onshore and offshore, oil and gas, petrochemicals, power and infrastructure sectors. His experience covers all aspects of the contract and EPC sector, from procurement, design, engineering to construction. The leading directory, Chambers and Partners, described Shourav as a first-rate, very experienced construction disputes lawyer, a well-read and articulate and with substantial knowledge of construction-related legal issues. And I'm sure by the end of this session, we will learn why. Thank you everyone for joining us today. Thank you for all the participants. I understand we are nearly 1,000 participants, and we will be having poll questions every 5 questions or so. And we will be requesting the participants to share their opinions and see how we can get the panelists to comment on your views. We will also be taking questions at the end of the session. We have received questions from over 200 people, and some of these questions are burning issues of the construction legal sector, and we are all excited to hear the views of our panelists here today. Now, construction is a major sector in India. Indeed, for an agrarian economy like India, construction is the second largest industry, and it is also the second largest employer and the second largest recipient of foreign direct investment. The general mantra is that where large projects exist, disputes will arise. In India, it's slightly different. Even when there are smaller projects, disputes will still arise. Construction disputes in India can be resolved by the entire full spectrum of dispute resolution methods. Arbitration is the preferred route, and most contractors and employers refer their disagreement to a dispute board or mediation committee, and which is then followed by an arbitration. Now, Indian parties have traditionally preferred ad hoc arbitration involving retired High Court and Supreme Court judges serving as arbitrators. For some disputes, it's not uncommon to have retired engineers act as the arbitrators as well. Lately, India has also seen a tremendous growth of senior Queen's counsels and barristers who are serving as arbitrators. And this has seen a very interesting angle where there's a dynamic between practitioners and retired judges serving in the same panel for the dispute adjudication mechanism. India has also seen attempts to promote institutional arbitration. We have seen the MCIA established in 2016. We have seen an international arbitration center in Hyderabad. Both have a very enviable caseload. Even though India has got much distance to cover in the race to becoming an attractive seat of arbitration. We've also seen the development, introduction of a concept of the Arbitration Council of India, which seeks to accredit and regulate arbitral institutions. We have not yet seen how the Arbitration Council of India will pan out in terms of its practical inputs and practical ways of dealing with the issues pervading in the construction arbitration sector in India. But all of us would be eager to hear the views of the panelists here today. The first and foremost reason for us to have a session on concurrent delay is the reason that is because most projects in India are plagued by delay. Now, before we understand what are the ramifications of concurrent delay and how contractors and employers are supposed to take on board these issues, I would like to hear from Mr. Lakshmanan, Mr. Ramaiah, if he can explain to our audience what exactly and what is concurrent delay. Mr. Ramaiah?
Thank you, Adarsh. Good afternoon, Justice Sikri sir and the panelist and audience. To define concurrent delay, there should be two delays, one from the employer and one from the contractor. Generally, employer's delay we call as excusable delay, where the contractor can get compensation. And if it is contractor's delay, we call non-excusable. That means non-compensable delay. So there should be two delay, and the two delays should be capable to delay the project independently. That means there should be different cause for both independently working separately to delay the project. Therefore, what we could say is there are two delays, one caused by the employer, one caused by the contractor. Both are critical, delaying the project in a critical manner, pushing the end date, right? So what we could say is an excusable delay and a non-excusable delay happening simultaneously in the same start date and same end date could be called as a concurrent delay, right? So we could define this as a true concurrent delay. True concurrent means, when I say true concurrent delay, the delay starts at the same time and ends at the same time. For example, let's say the parties agree, the employer agree to provide a land on a certain date and the contractor agrees to mobilize his machinery on a certain date. Both parties simultaneously delay for say 30 days. So that 30 days is capable of delaying the project, and therefore we call 30 days as concurrent. So wherein both employer and the contractor becomes responsible, and this issue is contentious. So who should bear the delay, who should bear the cost is questionable. Now, to elaborate it, many a times we don't see a true concurrency. So therefore, we'll have to rely on Keating's definition of concurrent delay, where he says the concurrent delay need not be at same time, starting and ending. It can also overlap. For example, let's say a contractor has delayed mobilizing his machine, a piling machine, to do a foundation, right, for a period of 60 days, in between which 20 days has been delayed by the employer in issuing a critical drawing to do such piling, right? Now, therefore, that 20 days also can be taken as a concurrent delay, right? So that 20 days is both parties' delay, concurrently affecting but different costs, right? So this also happens. So this is what we call as Keating's delay. Now the problem becomes more worse to analyze a Keating's delay, right? Now, in order to further talk about this, there are different views. Some projects we have a defined critical path. Some projects like EPC, we see changing critical paths. And there are many views on concurrent delay as to dominant delay causer, sharing of the concurrent delay, and kind of prevention principle. All this has been discussed, but there is no solution. So I stop there and leave it to Adarsh for the next.
Thank you, Mr. Ramaiah.
Yeah.
The next question is to Mr. Shourav. Mr. Ramaiah has already alluded to a couple of examples. Could you elaborate on some of these examples and illustrations and provide us with an illustration of where a project has seen concurrent delay?
Yes, good morning and good afternoon, Mr. Justice Sikri, fellow panelists. Mr. Ramaiah has also already indicated certain obvious initial stage delays where both parties have contractual obligations to do certain things, the employer to provide access or land and the contractor to mobilize, and both are delayed in their respective obligations. more often than not in projects, at least internationally, we see another unique kind of concurrency or delays happening at the same time towards the back end of a project, where the contractor is in culpable delay. By culpable delay, we mean for which he cannot get an extension of time. And a variation or a change is instructed in the work, which also will take time to complete. And that's what the classic sort of situation we see. It's important to take this in two stages. The first is to talk about the nature of the delay event itself, rather than who bears the risk of it. So before one can even talk about concurrency, one needs to look at the event. Has the event caused, or does it have the potential to cause actual delay? And we know in recent cases, maybe about 10 years back, in Adyad versus SD Marine, the court said there is no scope for theoretical delays. We need to look at actual, factual, common sense sort of delay. So first you identify the two events of delay. And these two events may be matters for which the contractor and the employer are responsible, inculpable, but it could be a delay for which the employer is not responsible, but for which the risks are somewhat shared. For instance, a neutral event. And in the last couple of years, that's what we've been seeing a lot. So Mr. Ramaiah's example was of an employer and a contractor delay, but you could also have a neutral event, for instance, COVID, which delays matters, and the contractor could be in culpable delay at the same time. Those two delays are also concurrent delays. Even though the employer is not responsible for force majeure, he didn't create it, the risk is contractually provided for. And so there could be two delays, and that could have, later on when we discuss prolongation cost, have an impact on that. So those are the kinds of matters that one usually sees, a lot to do with change or variations instructed close to the original completion date of the work or close to the new revised completion date of the work, and the impact of that change and of the contractor's own culpable delay or inexcusable delay.
Thank you, Shourav. The next question is to Mr. Singhal. Now, from a consultant's perspective, how does one ascertain if two delay events overlap? So say if two or more delay events occur at different points of time in the contractual period, can they be said to have caused concurrent delay?
Thank you, Adarsh. Good afternoon, Justice Sikri. It's a pleasure to be here on this panel with you. And good afternoon, everyone, and also other panelists. The topic of today's discussion on concurrency is very important. In fact, based on my experience of doing a lot of Indian projects, I see concurrent delays, what is being debated and discussed in almost every forum. Typical issues are land is not made available, the contractor is running, not running. Typical issues are maybe 70% land is made available, but the contractor says 30% land is not given. So whether there is a delay because of the non-availability of 30% land, like this. So these are the situations of concurrent delay. Now, as Mr. Lakshmanan Ramaiah said, the first and foremost is a concurrent delay situation is delay caused by contractor, delay caused by employer. Now, in such a scenario where delay is caused by both the parties, the first and foremost thing is the delay has to be critical. When I say critical, what is the meaning of critical delay? As Mr. Lakshmanan also said, a delay which affects the end date of the project. I'll give an example. Let's say a house has to be constructed and a roof drawing has to come from the employer side, but the contractor has not mobilized his people for probably constructing windows. Now, employer may argue that the team for setting up the windows or constructing the windows should be there, but he is arguing this point at a point of time where the roof itself cannot be constructed because the drawings for the roof is not there. Now, what is most important is this is a situation where probably the contractor team for window installation should be there and employer should have released the drawings for the roof. Is this a situation of concurrent delay? No. A situation of concurrent delay will be a situation where both the employer and contractors delay issues are critical, which means if the contractor has not mobilized its scaffolding or its manpower or its team for roof construction, that may probably to an extent be a critical delay at the time when roof is the driving issue of the project, of the construction of the house. Now, the question which Adarsh has put to me is, as a consultant or as an expert, what is required? How do you analyze that? You see, it's a very complicated issue, which is very difficult for any, by way of facts to determine whether there is concurrency or not. Because as I gave you an example, it could be that letters have been written by the employer windows, a team is not available to the contractor, and contractor might have said roof drawings are not available. So in such a scenario, we do what we call as a concurrency analysis. We find out that at what stage of the project, what is the delay taking place from the employer and the contractor. We find out at that stage of the project what is critical, means if the roof construction was to be undertaken at a particular stage, then roof is critical, it's not the window construction. And once you identify what is the area of criticality, then you identify what are the delays caused by the contractor and employer, and then you find out how much is the extent of concurrency by way of concurrency analysis. The second part, I think, Adarsh, you asked me what documents are required.
No, Rohit, I was wanting to know if they occur at different points of time, if two or more delay events occur at have different start or end points, can they still be said to have caused concurrent delay?
No. So as Mr. Lakshmanan said, one is a concept of true concurrency, which doesn't happen, which is rare. So let's keep that aside. The other thing is a concurrent delay has to pass what we call as a test of 7 issues. And one of the issue is that the delay has to occur more or less at the same time. Now, it may not be exactly to start on the same date and exactly to finish on the same date, but it should be reasonably more or less in the same period of the project when the delays are taking place. So, for example, as I gave you an example, window mobilization or window issue could come maybe 6-7 months down the line after the roof. But when the roof issue is there, if the roof issue is delayed by non-availability of drawing because of employer or because of the contractor's team for roof not being in there, that is a situation of concurrent delay. So for a concurrent delay to be alleged, it has to happen at the same time that both the parties are delaying the project more or less at the same time.
Understood. Thank you, Rohit. This is an interactive session. So we have put in some questions in the form of a poll that we will be sending to the participants. Now, on your screen, a question will appear with 4 options. We'll be giving you about 1 minute to reflect on the question and the 4 options. And we would like to hear from you whether what you would consider your response. So the first question is, contractors are not automatically entitled to costs, even if they are able to establish extension of time. And I would like to hear the participants, their views on whether they strongly agree to strongly disagree. And if they, of course, if you have no opinion or you would not want to express any view, feel free to not answer the question.
So I think Adarsh is just putting the poll question, so we'll just wait for a few seconds.
Yeah. So no, it's good. That should also happen simultaneously.
Yeah.
Yeah.
Is the question, do we have the results of the poll, or
We can take up the results later on. We can continue with the discussion. Thank you.
okay. Now, first things, now that we have heard what concurrent delay is, and in what circumstances concurrent delay can take place. We would like to hear from Justice Sikri, where in a situation where both parties are culpable for different delay events, how do you see Indian law dealing with such a scenario where concurrency exists?
Adarsh, thank you very much for putting this question. Actually, the other three speakers have already stated about the concept of concurrent delays and what approach should be there. Now, therefore, at the outset, what I can say is that whenever the disputes arise and the matter goes for arbitration, one has to look into this particular aspect as to who is liable for delay. And in the process, the question of concurrent delay comes as a facet of that. If I may start by saying that this is, as far as delay aspect is concerned, and then consequently concurrent delays, it is very peculiar to construction industry. Of course, such an issue may arise in any kind of arbitration, or in any kind of contracts and their disputes. But there are certain peculiar features of the construction contracts, and therefore they lead to some kinds of issues which then are rigged up during the arbitration proceedings, which have to be kept in mind. One is that these are very highly technical, the contracts, because all these construction contracts, they may vary from, say, shipbuilding to oil rigs to the big projects like hotels, township, hospitals, and even the commercial complexes, etc. So therefore, the various kinds of these highways, national highways, and such other contracts, and the question of delay when it comes to, or during whether the contract could be performed within that period or not, and the time was overshot. Depending upon the nature of the contract, the reasons for delay may also be different. Because this is what we have to keep in mind as arbitrators, because the issues get arisen keeping in view that particular nature of the contract, and the issues are normally very, very complex, because when the certain things are very technical, and where the obligations of both the parties are there, and reciprocal obligations which are to be performed, what was performed, what was not performed, at what stage it was to be performed, because then the question of concurrent delays comes. What stage it was to be performed, all this has to be seen in the background of that particular contract. So that was my first comment which I wanted to make. Second comment is, and that is why we are discussing this, that invariably, which the other speakers have also said, invariably these construction contracts or the projects are not completed within time. Maybe more than 90% cases, the extension has to be given, and so delays take place. And as I mean, all of the speakers have said, and rightly so, that normally then when the disputes arise, of course, because of this delay, as far as the contractor is concerned, the contractor would say that the costs have escalated, and because of that, I have suffered the losses also. Many times the issue comes for consideration, because if the contract was not completed, even after giving extensions, etc., so we find that employer at times terminates the contract as well. So therefore, whether termination was valid or not, whether it was because of the faults on the part of the contractor or on the part of employer, the question of delay again, even while deciding whether the contract is validly terminated or not, this issue gets cropped up. And of course, then in such a situation, the question of not only escalation of cost and overrun of cost, but depending upon if the termination is right or wrong, the claim for loss of profits and other claims, they also come up. And therefore, I have seen my limited experience now 3 years after my retirement as judge, and many cases which I have done. Of course, as it was said, and 50 to 60%, or maybe sometimes 70% cases are construction disputes. And therefore, in most of the cases, first and foremost, that the issue which is to be resolved is the delays which are admittedly there, on whose part and who is at fault. And as Mr. Singhal rightly pointed out, it is the criticality of the delays. Delays may be there on both the parts, but which delays are critical? And in the process of these critical delays, we have to see that concurrent delays, if there are. And I need not say the other speakers have mentioned about what is to be seen and whether there is a true concurrency or not, and what is the test which is to be applied, whether it is almost at the same time, and concurrent analysis is to be undertaken, and in that process, what are the critical delays that has to be undertaken. Now, having said so, the question that arises is, insofar as, let me first tell you as far as how the courts have dealt with when the award is passed and the award comes before the court, and if it is challenged under Section 34, there the law is clear as far as courts are concerned. There may not be much of a problem, because the courts have said that ultimately, and we know the celebrated judgment in Associated Builders versus DDA in 2015, authoritative pronouncement was this, that it is the tribunal which is the final adjudicator, because ultimately this delay is a matter of analyzing the evidence, etc., and it is the tribunal which has to do it and undertake this exercise. But the law also says at the same time that there are judgments, and in one of the NTPC versus Shri Avantika contractors, the courts had said that, look, it's of the Delhi High Court, but then it is mandatory to give reasons. So the award of the arbitrary tribunal has to be reasoned one when it analyzes the delays. So, but once the findings are given, and the findings are, those were the possible findings. Of course, under Section 34, we know that the courts do not sit as a court of appeal to see whether the finding is right or wrong. But therefore, what becomes important is that the issue, what has to be decided by the arbitrator, and whether the proper evidence comes or not. Let me tell you, and as you have mentioned while giving the introduction of Mr. Rohit Singhal, that he is an expert and has been given expert evidence, etc. Depending upon, and that is why in the beginning, I had raised the issue of complexities of construction project depending upon the nature of the project. So therefore, there has to be a sufficient evidence before the tribunal, which has to be led by both the parties. Of course, ultimately, this analytical observation, or analyzing that evidence is the task of the arbitrator. But I have found, particularly in domestic arbitration, in many cases, this question of concurrent delays or question of critical delays, etc., no proper even evidence is led. What is done by both the parties, and this is from my limited experience, I am saying, of course, things are changing. I'll come to that also. That, but as it was, mentioned by all of them, that there would be different, reasons depending upon reciprocal promises which are to be, or obligations which are to be carried out by both the sides. So the contractor will blame the employer, and employer will blame the contractor. So whether there was delay in handing over of the site, or it was the drawings, etc., were not this good for construction drawings were not given, or the decision where the employer had to give, apart from giving the site, etc., all those. And then, of course, some obligations of the contractor also, mobilization of the resources, the machinery also, manpower also, giving off. Sometimes the contract gets signed later in point of time, say, because in the beginning they have to give bank guarantees. There may be delays in that. But question is, when we come to critical delay, and then we have to see the concurrent delays, which are that part of concurrent delay. As I was saying, both the parties will just say this has happened on this on account of the contractor, and employer will say that, and contractor will say that this has happened. But that analysis which is required, that many times is lacking. Of course, things are changing, and I have seen in many cases where the expert evidence is led, that it can be done in two ways. I have seen in many cases where in these projects, independent engineers are appointed. Those independent engineers, particularly when the extension of time is to be given, because what happens, what is the effect of that delay? I have said as far as contractor is concerned, he may ask for escalation and on various accounts and higher amount, etc. will say I have suffered damages. Insofar as employer is concerned, it's a question becomes of a grant of extension of time. And even if it is to be given, if it is with LD, so employer may have imposed that liquidated damages. So both have to justify. So I have seen in many times when the extension of time is given, yes, independent engineer does that exercise, and it says that look, there was this much delay was on the part of the employer, this much delay was on the part of the contractor, and this much was the concurrent delay which can be excluded, and the net result is this. If such a analysis is there, which has to be done by experts, because it can't be, but as I have seen many times, both these sides will only rely upon their letters which they are writing during the execution of the contract, blaming each other, and will leave at that. That makes the task difficult for the arbitrator. But of course, having said so, what is necessary is that either at the employer level, that is through independent engineer, this exercise should have been there, whether accepted by one party or not, that may become a matter of dispute, which can be always resolved by the arbitrator, or the parties should produce the expert evidence. But when coming to expert evidence, again, the task of the arbitrator becomes little complicated in a situation where on both sides, experts are there who have given their evidence, and those aspects are also, we have seen, who have given their respective evidence, but then the expert produced by the employer is saying that the contractor was responsible, or most of the time contractor was responsible, and vice versa, but then there is no unanimity. So in these circumstances, what I feel is that, yes, there are certain methods which are adopted by the arbitral tribunal in dealing with these situations. One way is that both the experts, we say that you sit together, what are the aspects on which you agree? And what are the aspects on which you disagree? I have done so in a few cases where it has brought the results. And therefore, we have to deal with only those, because when they sit together on because there are many presumptions also on the basis of which they work. So whether those presumptions, so they may, when they two experts who are independent, and expert may be produced by one party or the other party, but then they are supposed to be independent, doing their independent analysis, and their function is to guide or to assist the tribunal in arriving at a correct finding. So therefore, when they sit together, we have seen 40 or 50 or 60% aspects are thrashed out where they agree. On certain aspect, they don't agree. They may give rise to some legal issue or on some factual issues, but then it would be easy for the tribunal to deal with that. But having said so, your question was that how the courts or how the Indian system is dealing with that. So my answer is that it is for the arbitral tribunal to undertake that exercise. And very good, I would say, guide is that this Society of Construction Law on delay and distribution protocol, which is mentioned, and it states, I think that all arbitrators and even parties or their counsel should read that. It gives a good guide, not only explaining what is the meaning of concurrent delays and how the concurrent delays are to be dealt with. Then there are different methods of delay analysis, 5 or 6 methods which are given, and which method should be applied under what circumstances. So that is the exercise ultimately to be done by the arbitrator or the arbitral tribunal. Arbitral tribunal should objectively consider all this material and give a reasoned finding. Once that is done, The law in India, as I have narrated those judgments, very clearly says that, okay, if it is a reasoned order and the conclusion which are arrived at were possible and under Section 34, then it is the arbitral tribunal which was to adjudicate on these facts, and therefore we would not interfere. That is what I would say.
Thank you, Mr. Lahiri. Thank you, Justice Sikri. Our next question would be for Mr. Lahiri. And I must say that I'm very amazed that we have a very sophisticated audience, because the last question we had almost unanimous agreement that contractors are not automatically extended to costs if they are able to establish extension of time. And there was 46% agreed with the statement and 40% strongly agreed with the statement. So that was great. Mr. Lahiri, what is the English law position on concurrent delay? We've heard heard Justice Sikri explain how Indian arbitrators, the Indian courts look at it. What does the English law state about this?
Yes, and thank you. And of course, today we are talking really about the position under Indian law, but it's interesting to look at how other courts have dealt with it, particularly English, and I'll also talk about Scottish courts. But let me start by picking up from a point where Mr. Justice Sikri talked about, and that is proof and an attempt to prove rather than assert. So under English law, you have a two-stage test. First is identifying if there is concurrent delay. And secondly, you look at what the effect is if there is concurrent delay. Now, on the first stage, it's quite simple. It's actually a question of causation. And the law treats causation as a matter of fact. So the factual evidence of what was happening on the ground at the time is extremely important. And that comes from the factual witnesses that are brought out, or the correspondence, which is a good guide to what was happening, the monthly updates, programs. The second element of causation is criticality, something that Rohit raised and Justice Sikri raised. And that traditionally, at least internationally and under English law, requires some assistance. The tribunal requires some assistance from experts who can look at way the contract was performed, the way the programs were arranged, to see whether, even though this delay may have been factually caused by a certain event, whether it was critical. So both these elements are required or prerequisite before one can really talk about concurrent delay. These two events, and Rohit has alluded to it, and Mr. Ramaiah may also have done so. These two events the delaying event as such need not occur at the same time. There is some view, a case called Royal Brompton Hospital, which takes a slightly different view. It says that the delay event must occur at the same time and the effects must be felt at the same time. But as Mr. Ramaiah raised the SCL protocol, Justice Sikri also raised it, SCL protocol sort of describes this as true concurrency, which all of us know is rare. So the kind of concurrency we are really talking about is a commonsensical concurrency. There are two critical events, the effect of which delays the project at the same time. So it doesn't need to happen. The events can be sequential, but the effect of it must be concurrent. And that's the primary way of identifying what the delays are and if they're concurrent. Now, once we have done that with the assistance of both factual and expert evidence, if possible, but at least factual evidence, that's important. One then goes on to look at, so what? So what is the effect of this? And this is where let's start with the English law position. And the English law position today, even today, is actually set by a case some time back. It's called Henry Boot and Masin, or the Masin approach. And in very simple terms, it says that if there are two concurrent delays, one of which is a relevant event. In the JCT contracts, the capital R, capital E relevant event is an event for which the contractor is entitled to an extension of time. So if one of them is a relevant event and one of them is not one, that means the contractor is responsible for it, the contractor is entitled to an extension of time for the entire period of delay. Now, in that situation, the reason why the contractor is entitled to an extension of time is actually a prior principle that an employer ought not be able to, or no party ought to be able to take advantage of his own wrong or a risk that he has borne. So the reason why contractors are granted EOT in itself is irrelevant. It is relevant only because it avoids imposition of liquidated damages. So what the law is really saying is that because employer, you are responsible for a relevant event which occurred concurrently with an event for which the contractor is responsible, you, employer, don't get to impose liquidated damages. That's the principle. And because of that, how do you contractually ensure that? You contractually ensure that by giving the contractor an extension of time, because an extension of time revises the completion date, and therefore the incidence of liquidated damages doesn't happen. Now, just a little cautionary tale before I go on to how Scottish law looks at it. Little cautionary tale, even under English law. It is possible to contract out of the effect of what I've just said. And because English law is fairly clear on what the effect is of concurrent events, that the contractor gets a full EOT and the employer doesn't get LDs, there have been situations, and we've seen that in a case called North Midland and Sidon Homes. I think this was 4 or 5 years ago, where in the contract itself says, if there is concurrency, the contractor still doesn't get an extension of time, provided he is liable for or culpable for an event at the same time. So it sort of contractually removes the effect of what I've just said and grants the employer the entitlement to levy LDs, even though he is responsible for a relevant event that happens at the same time, concurrent relevant event. So that is, it's possible to contract out of it. There's no mandatory principle, but that's the general principle. Now, Scottish law, the base of Scottish law is different. The origins are different, has looked at this situation slightly differently. And it's not an exception or just an aberration, because actually the Scottish law position has been followed in Hong Kong, in Australia. So it's a viable alternative option, particularly if a matter is not governed by English law. So for instance, Indian law matters or other law matters. This is a viable way of looking at it, but with some problems. And it's what Scottish law says. And the two main cases on this are Doyle and Lang, John Doyle and Lang, and Citian and Shepherd, about 10 years ago now. And Scottish law says, if you have these two critical parallel events, let's just say parallel events causing parallel delays, concurrent delay, there needs to be an apportionment, because no two events, as I say, have the effect exactly in the same period. There needs to be an apportionment of liability between the employer and the contractor for this period. Now, English law would not say that. English law would say contractor is entitled to an extension of time for the entire period. But Scottish law says no. The contractor is entitled to an entitlement to an extension of time or relief from LDs for a portion of the period for which he's not responsible. And the employer is entitled to levy LDs for a portion of the period that the contractor is responsible. So a principle of apportionment. It brings up certain problems because technically, if you follow the analysis all this way, for the period for which the contractor is entitled to an extension of time, he should get prolongation costs. We'll come to that in a bit. And for the period that the employer is entitled to an contractor is liable for delay, the employer should get LDs. So practical difficulties arise in apportionment on how you then deal with the consequences of apportionment. So that's a Scottish position. As I said, it is followed in some jurisdictions, but the English position is fairly clear and it's different from the Scottish position.
Thank you, Shourav. I must say that the distinction between the English law and the Scottish law approach is also to an extent reflected in India. We have a Delhi High Court decision of 2020 involving IRCON and CR Sun builders, where the court did not interfere with the tribunal's findings in relation to concurrent delay and apportioned costs, the prolongation cost to an extent that the contractor was entitled to it. This was also seen in Bombay High Court decision of 2011. But on the other hand, we also have the English law approach being followed by a 2013 Delhi High Court judgment where only an extension of time was granted and nothing more. So before we take on the next set of questions, I would like to take on the second poll question and see if the participants can answer the second question. Now we'll have the question. I'll just read out the question. Project managers and contract administrators are aware of the difference between excusable and compensable delay. And if you could just answer to the extent you agree or disagree with the statement, we will proceed with sharing the results with you. Okay, let's look at the next set of questions in relation to interpretation of contractual clauses. And this is very interesting because it's we received a lot of questions from participants in relation to exclusion of liability, limitation of liability. And I would like to ask Justice Sikri the first question. Justice Sikri, many contracts with public sector undertakings or state agencies have what can be referred to as interim provisions, such as price reduction clauses or exclusion of liability clauses. How do you reconcile these contractual terms vis-a-vis the requirement of a party to prove actual damages or to make sure that no contractual clause is unconscionable or unfair?
Actually, this is, I think these issues which you have raised are not only a matter of heated debates, if I may say so, almost which arise in all these contracts, because such clauses we find wherever the contract is with the public sector undertaking or with the government. And number one, but number two, more importantly, the case law which has developed around these clauses, that has also created problem to some extent, if I may very frankly and bluntly say so, because you will find cases on either side, judgments on either side, to which I will advert to and discuss that. You have raised two aspects as far as these clauses are concerned. One is price adjustment clause and other is exclusionary clause. The two are to be taken up separately. Insofar as price adjustment clause is concerned, normally what happens is that the clause is mentioned in a manner that if there is a delay on the part of the contractor and delay is so much, then the price which is agreed upon, the price of the total price of the contract will stand reduced by a particular percentage. And so therefore that is one aspect. And simultaneously we find that in such contracts, there's always a provision for liquidated damages. So therefore the contract would also provide, if there is a delay on the part of the contractor, then extension of time will be given by imposing liquidated damages. And the clause relating to liquidated damages generally say it would be X amount per week of delay or per month of the delay, subject to a cap is there, 5%, 10% of the contract price. Now, interesting situation which arises in the first instance, as far as this price adjustment clauses are concerned, that, okay, for delay, there is a clause for liquidated damages. In law, liquidated damages can be imposed. And because if there is a delay on the part of the contractor, and because of that delay, employer has suffered the damages, and because the project, because we are talking of construction contracts, so project has been delayed, it may not be possible to quantify those damages. So predetermined damages in the form of liquidated damages, which is very well recognized, and it is a valid clause in terms of Section 74 of the Contract Act. Unless liquidated damages are prohibitive or they are almost penal in nature, on which the case law has developed. So therefore, that clause is there. For delay, the employer can give the extension and impose those damages, liquidated damages. But at the same time, when we talk of, in certain cases, and we have seen it of late in many such contracts with public undertakings, price reduction clauses have also been added. So they can impose liquidated damages, but at the same time, contract price will also stand reduced under that price reduction clause by such and such percentage. So in such a situation, the question arises. So we are not on LD that may withstand or that may pass the muster of Section 74, no problem. But whether this price reduction clause is in the nature of a penal clause, and number one. Number two, whether you can have this when you already have imposed LD also. So these are the issues which arise. And interestingly, the arguments of the employers in all such contract is that is of a different nature altogether. Price variation clause is totally different because the price was considered keeping in mind that the time is the essence of the contract, and the contract would be completed within a specified time. And as that has not happened, and this was something which was, one can say, some incentive was given to the contractor by fixing that price, and that incentive is withdrawn now by reducing that price. A sort of ingenuous argument which is normally raised, and therefore it is not a penal clause. And interestingly, I have seen, because in one of the cases, the 2 or 3 cases in arbitration, this has come before me. And in one of the cases, one English judgment was also cited. Lahiri will be able to throw more light on that. I don't remember that judgment now, where such clause is treated as a valid clause under the English law, where it is distinct from clause pertaining to LD. But only thing is that in India, it has not happened that way. In India, the clause are that once you impose for delay liquidated damages, then you can't reduce the price also. They, of course, I think 1 or 2 high courts have given that judgment. Maybe matter is pending in the Supreme Court. But so therefore, argument is on this, whether there is a fundamental difference between a jurisdiction review, the substantive fairness of a contractual obligation, that okay, in fairness it is there, or jurisdiction to regulate the remedy of its breach. So that kind of dispute which is raised by the employers in such circumstances. But in so far as India, as of now, the law is that you cannot resort to price reduction at the same time when LD is also there. Now, coming to exclusionary clauses, which you point out, that again raise very interesting issues in the Indian context. And in respect of price reduction clause, let me only say one thing more, that Supreme Court has said, insofar as law on damages for breach of contract is concerned, Indian position is different from English position, because it is a self-contained and whole machinery is provided, and self-contained code, which is encapsulated in Section 73 and 74, 75 of the contract. So therefore, the case has to fall within the parameters of these. We can't go into the other aspects, or can't take into consideration the common law which has been developed on certain aspects in English courts. So therefore, that is one aspect on the basis of which the courts have held that when it comes to price reduction, when LD is also there, though it may amount to something which is penal in nature, which is not permitted either under Section 73 or 74 of the Act. And if it was, okay, 74, you say, predetermined, etc., then it is already you have taken recourse to LD. So how you can have both the clauses together? So that is one rationale which is adopted by Indian courts. But going by the, I mean, insofar as the I would say the concept of reduction of price is concerned, the way it is developed in English law or by the English courts, they have treated it as different from LD, but that has not been accepted in India so far. That is the position. Now, coming to exclusionary clauses, here, interesting thing is, as you have heard, most in many such cases with public sectors or the government, the clause normally provides in case, admitting in case there is a delay on the part of the employer, in such a situation, only suitable extension of time shall be given and the contractor shall not be entitled to any compensation. That normally is the clause which we say exclusionary clause, which is pressed by the employers in such cases, that even if you find, even the arbitral tribunal finds that delay was on our part, extensions we have given, maybe those extensions were I mean, with LD or without LD, etc. But then if the contractor is making a claim for compensations or for damages, etc. on that ground, or loss of profits, all those claims are not entertainable in view of this clause. Now, the argument is simple. On the one hand, look, you had accepted this clause and you are bound by the clause. Arbitral tribunal is the is supposed to decide in terms of the contractual provisions. Contract clearly says that in such circumstances, the contractor is not entitled to any damages. So therefore, there is no jurisdiction with the arbitral tribunal to grant the damages contrary to the terms of the contract, which was accepted. In nutshell, I am saying so, where it can be expanded to any levels. On the other hand, the contractor would say that, look, this merely because this clause is there, that doesn't mean that you can prevent me from claiming the damages, because this right is given to me under the Contract Act. It's a statutory right. And if delay has taken place and this finding is recorded, it is axiomatic and it is the necessary consequence thereof that the contract was prolonged. I had to put my labor also, machinery also for 1 year or 2 years more. The cost of material had escalated during this period. So in fact, I have suffered loss and I'm able to prove that loss. So therefore, if I'm able to prove, and Contract Act Section 73 entitles me, because if there's a delay on the part of the employer, it amounts to breach. I have suffered the loss. Section 73 gives me right to claim that loss, and therefore this clause should not come in my way. Now, as I said, these may be these are the counter contentions and counter contention of the parties. But then as I said, the way the case law has developed and how it has come to ultimately, which I had an occasion to analyze in one of the awards in a very detailed manner. Of course, now that is not a public document, and awards are not judgments in that sense. So therefore, it is not. But I had, but thereafter, I have written an article also, which maybe it is going to be published in a book, and how my analysis, which I have gone into on these aspects. First, let us see, and I'll give you only 1 or 2 cases, how the case law has developed. In Saeed Isras Masood versus State of Madhya Pradesh, where the similar clause was there, and the damages were granted, the court said that no, you could not have given contrary to what is stated in the contractual provision, which was even in this Associated Engineer versus Government of Andhra Pradesh. And more importantly, I will give the judgment in Ramnath International Construction versus Union of India, where the clause provided no claim in respect of compensation or otherwise, howsoever arising as a result of extension granted under conditions so and so shall be admitted. And court went on that basis and said that it could not be given, and there are few judgments on that basis also. But then what happened there? in some of the cases, the courts have, they had granted the damages. And I give you example in Asian Tech Limited versus Union of India, while interpreting a similar provision in the contract, the apex court came to the conclusion that notwithstanding such a clause, the contractor could make a claim for further amount. And this ultimately was, this Asian Tech and ONGC, Big Brother, Gale India, etc. This was decided. But in one case, the Supreme Court said that, look, Ramnath International was a judgment decided by 2 judges, where other judgment decided by 3 judges. So we will lean in favor of granting the damages. To that extent, now the courts are saying, notwithstanding such a clause, the arbitrator would be competent to award the damages. And of course, all these have to be dealt with. And in one case, if you know, Delhi High Court, this was the judgment given by Justice Malmiki Mehta as at that time. He went one step further. He even said that such a clause which bars the contractor to claim damages is contrary to the Contract Act Section 23 and therefore it is contrary to public policy. And therefore he went to the extent of voiding such a clause and said that Section 73 is there. This clause is against the public policy. So we may not go to that extent, but let me tell you what my analysis, and I would say that what my solution, which I have found in one of my article awards, 1 or 2 or 3 awards which I have given, and in that article which I have written ultimately, that what should be the suitable approach. Number one is, what is to be seen is that the exclusionary clauses, if you see, they normally talk of reasonable extension of time. That normally that word is that reasonable extension would be given. It is interpreted, I am saying, again, not discussing those judgments for paucity of time, but saying, then the courts have said, look, at the most, if it was reasonable, means, few months extension, etc. was needed. This clause cannot be there if the contract has delayed by 2 years, 1 year, 2 years, or 3 years, or suppose the original period was 36 months and there's a delay of 36 months again further, or 40 months, then you can't invoke such a clause. If there was a reasonable delay, means 1 month or 2 months, okay, you might have invoked, and therefore the contractual provision contemplated only the reasonable delay and not unreasonable delay. That is one escape route which is fine to award the damages in such circumstances. Other is which is adopted by certain courts, which I have noted, business efficiency test, and where it is said that, look, every businessman, and when even the contractor, when he submits tender, he has this business efficiency in mind, that that the contractor would arrange his affairs in such a way, okay, if I am awarded this contract, the contract period says it's 3 years, so I have to arrange all my resources for 3 years, and within these 3 years, I have to complete the contract, and therefore the contractor is supposed to mobilize, therefore he knows how much resources I have to mobilize to this, and what is the money I would be requiring to complete this, and how much I would be earning, and how much would be my profits, etc. So therefore, if this business efficiency test has to be kept in mind, there are 2 or 3 judgments, again, I'm not going into that, which again go back to the same position, that if that all is upset, those calculations, and the fault lies with the employer, who and because delay had taken on, because we are contemplating a situation where delay is on the part of the contract employer, and still the employer says that I don't have to pay the damages. So therefore, assumption is that we are discussing those cases where the delay is on the part of the employer. So therefore, if the all these calculations which were made, or planning which was done by the contractor while undertaking that contract, and while getting that contract, then he should not be punished by denying him the damages also. And third, which was very interesting, was that look, we have to, and this is now interpretative tools which are adopted by the courts, and there are some judgments on that, interesting judgments on that. First is a strict interpretation should be applied to such a clause. Once the clause is there, then strict, and there again I come to the same, that strict interpretation means only reasonable, not only reasonable. The courts have gone to the extent of saying that okay, some delay occurred, but it was within the period of contract only. So if the contract was 36 months, then the drawings were to be, suppose whenever the good for construction drawings are to be given, these are given within 1 month or 2 months, but all that has happened within the period of contract. And because of this, contract was not extended, or no question of extension arose because of the fault of the employer, okay, we will accept this clause. But not if the delay results in crossing the boundary or the sense, and then it results in this. So that there are certain judgments on that also. And another aspect which is said is, and another very interesting, in one of the judgments, the court said, I think it's again a judgment of the Supreme Court also and Delhi High Court as well. Okay, this clause says no damages, no compensation. It is binding only on the employer. Employer may not give itself, but that doesn't bind the arbitral tribunal. Arbitral tribunal is not bound by such a clause. When the claim is preferred by the contractor with the employer may reject. But when it comes to the arbitral tribunal is not bound, and therefore arbitral tribunal will go by a law and can award the damages. So therefore, these are some of the I would say judicial wisdom, or this kind of niche is created and escape routes are created. Today, by and large, law is, if there is a delay, before the tribunal, it is proved by the contractor that delay was on account of the employer, and employer was responsible. Contractor is able to prove that because of that it has suffered losses or damages, then in law it would be entitled to those damages, and as law permits those, notwithstanding such a clause.
I'm really grateful for this thing. I think a lot of questions from the audience is also based on this issue, and there has been a huge amount of debate and discussion within the industry parlance, what to do and how to tackle with such a kind of scenario. I'm really grateful.
Justice Sikri, so many contractors, so many employers seek legal opinions from retired judges and senior lawyers on this clause. And of course, so many of them would have to grapple with so many of the case law. I think the Indian case law by Justice Valmiki Mehta that you were referring to is Simplex.
Simplex, yes.
Yes.
I've got that. Yes.
And Shourav will of course help us identify the English law position that you had identified and alluded to. So Shourav, maybe you can just step in and help us out here.
Okay. So a couple of things, I'll talk about that, but I was very interested to hear Justice Sikri's summation and analysis of the cases. And I must say, from an English law perspective, the Indian arbitrators and judges are being very creative to try and achieve some sort of justice in a situation which is a very civil law type approach. The English common law is very strict. So the benefit of the Indian law approach seems to me that somehow some sort of justice is achieved. But the disbenefit or the con is that certainty is removed. You really don't know what's going to be the outcome because the law is not certain. English law, particularly after Arnold and Britain in the Supreme Court, has been very clear. You look at the objective language of the contract and you interpret it. Parties can agree to anything. I mean, there is, unless it's illegality or certain fundamental principles, you can agree to anything. So I think the English law would be a bit hesitant. I mean, I can't say what the Supreme Court will do, but a bit hesitant on following the various channels or tributaries that Justice Sikri has talked about. I think, Justice Sikri, the case you may have been referring to, I wasn't there obviously, so I'm guessing, is Cavendish Square and Magdesi. And Cavendish Square and Magdesi, it's a pair of cases. 2015, I think 2016, 2015, 2016, both went to the Supreme Court, the former House of Lords, now called the Supreme Court. And the other one is called Parking Eye and Beavis, Parking Eye v. Beavis. And interestingly, the court ruled on both these cases at the same time in the same judgment, if I'm not wrong. And neither of these cases are actually construction cases. The issue the issue in question was the penalty rule. Penal, is the clause penal, going all the way back to Dunlop pneumatic, where you'd have that, if it's not a genuine pre-estimate of loss, then it's penal. And that rule has now gone under English law. McDessie, and it was interesting, give me a couple of minutes, I'll explain this. McDessie, in McDessie, the court held that the provision was not penal. Even in Parking Eye, they held it was not penal, but for different reasons. And the court distinguished between what's a primary obligation and a secondary obligation. The obligation to pay damages. So the concept of liquidated damages comes about as a secondary obligation. So it arises from breach. A breach of a primary obligation gives rise to a secondary obligation to pay damages. And the context, in that context, different provisions apply or different principles apply compared to a primary obligation. So if a certain event happens, you do something contractually, that's a primary obligation. And in McDessie, it was, if I remember, it was a share purchase, share sale agreement. And it says if certain restrictive covenants are not complied with, then the value of the share goes down. Very similar to the argument that Justice Sikri is saying about an incentive having been removed. And the court said, the court doesn't interfere in that. That's actually a primary obligation. There is no question of penalty or not. That's what parties have agreed. If a restrictive covenant is not followed, the valuation of the share goes down, perfectly acceptable. So McDessie doesn't even come in to deciding whether liquidated damages or damages are penal because it talks about a primary obligation. Parking Eye is actually very simple. It's a small case. It was basically, somebody was charged £85 for overstaying in a car park in a mall. It's as basic as that. But the principle is extremely important. And in Parking Eye, the court said, okay, now we are talking about a secondary obligation because the contractual requirement was you leave within 2-3 hours and you breach that and therefore you pay damages. When it comes to paying damages, that £85 per hour or whatever of overstaying, that can be whatever amount the mall owner decides. You don't have to assess whether that reflects his loss because there could be a completely different reason for that. That could be a deterrent. So it's actually possible for that £85 to be interim or penal. It's okay because it's meant for a different purpose, not just for compensation of loss. So given those pair of cases in Cavendish Square and Parking Eye, nothing to do with construction, but it has been brought into the construction field by law. I think if I'm not wrong, Justice Sikri, those might have been the case. That was obviously not there.
You're right, absolutely right. Yeah.
So
the only interesting thing is that because in both the cases it was only price adjustment clause or price enhancement, etc., as in parking case. But what happens in a construction contract where there is a provision for liquidated damages also, and there is a provision for reduction in the price also. So when these are to be taken up together, then maybe the Indian approach as of now seems to be correct. I mean, that is one view which can be taken. Of course, as I told you in one of, I didn't have to of course, go into that issue in that particular case because in that arbitration, because the claim was rejected on some other ground. But one, I mean, the issue which comes into this is that which was argued that look, one is as you have already, I mean, captured that from me, that it is price adjustment is on incentive, and that is so therefore it is not penal, and whereas liquidated damages are for delay. Maybe event is same delay, but there are two different consequences which follow, and both are permissible. That is one of the arguments of the employers. Yeah.
Yeah. Thank you, Justice Sikri. Thank you, Shourav. We are taking some questions from the participants now, and some questions are in relation to a concept called float. And before I ask Mr. Ramaiah about how his experience is, Rohit, can you quickly explain what is float and its intended purpose?
Yeah, thank you, Adarsh. I think so. The concept of float is that let's assume a particular activity has to be done in 30 days of time. But when an activity is part of an overall project, it could be that that project allows an activity to be completed in 40 days of time. I.e., for example, if I have to dig a trench, a 100-meter length trench, it will take 30 days for me to dig trench. But because after laying of the trench, I have to put a pipe into the trench and the procurement of the pipe takes 40 days for me to get the pipe, there is a differential of 10 days, which is that margin or extra time which is available for the excavation of the trench. Because if I excavate the trench in 30 days, I still will have to wait for another 10 days for the pipe to come. Now that's the concept of criticality, which means that can a delay in excavation of the trench by 5 days when the pipe which has to come into the trench has not yet come, will it cause critical delay? No, because that delay in the activity has a float in it. Now float is, whatever I have explained is a very basic concept of float. When we go and do analysis and all, we have to find out the total, there are various concepts of the least float method or the total float method or the zero float method and all, but they are quite advanced issues related to delay analysis. That's what I'll say.
All right. Thank you, Rohit. Mr. Lakshmanan, can you now tell us what your experience has been? We have heard of employers in India attempting to negate the usefulness of this float. So what has your experience been? Can you please share?
Yeah, thank you, Adarsh. As Rohit rightly pointed out, see, float is the number of days by which a particular activity can be delayed so as not to delay the project. So that's the idea of float. Now, the author of any program, as I understand, is the contractor. What I mean here is the creator of the program manufactures a kind of organized activities in such a way that some are critical and some are non-critical. Now, when I say critical, these activities, you can't miss the dates. You must execute on time. Otherwise, by all probabilities, you will be delaying the project. Now, when you call something non-critical, there are some activities which you can delay by certain number of days, which we define as a float, right? So that if you delay that activity by that amount, so it doesn't delay the project. Therefore, you can see float as a resource, right? Now, who owns this resource is a questionable item. To me, as a creator, the contractor understands what is float, and there could be many purposes for which he has created it. Probably he could have anticipated certain risk and he could have reserved certain, sometimes these protocols, SEL and all that, and some scientific analysis calls as padding. Padding is different from float. Padding is a process you simply add something without scientific evidence. For example, if you can do certain work in 5 days, you simply put 10 days. So the 5 days extra we call as padding. So padding is not a float, right? So a float is something when you connect certain activities automatically comes out as a reserve. And now the question is, certain contracts which I work with has a concept of purchasing the float. If I would read out the clause, it says the ownership of program floats shall rest with the employer. This means in Indian contracts, I'm talking in Indian contracts, this means this float as a resource is purchased by the employer at the time of tender, right? This is very risky. Now, why I'm saying this is, we have seen that the concurrent delay only occurs with critical activity. Now, by the way of purchase of float, all non-critical activities also becomes critical because somebody has purchased it. For example, once you start delaying the non-critical activity, one day it is going to become critical. Then the employer would easily declare that you are the dominant causer of the delay because I have purchased the float. So in order to explain this, let's take, normally we don't look construction projects at activity level. For example, some of our projects, the delivery of project is accomplishment of 100 bridges, let's say. Building of 100 bridges. For example, one particular bridge is critical, rest of 99 is non-critical. Right? Now, the critical bridge employer delays the drawing by 100 days. Non-critical bridge, which has a float of 100 days, the contractor delays by 200 days. Now, therefore, if the employer has purchased the float, it is a bit risky on the part of contractor, because he becomes the dominant causer of the delay right from the consumption of float. So this is the risk the construction industry faces. Now, there are various concepts of float, wherein some of the philosophy says the float owner is always the employer. Some says float can be purchased. Some of the philosophy says float can be shared between the parties like concurrent delay. And some concept says the float is a resource allocated by the contractor, and therefore the creator will have ownership on the float. This question remains unanswered, and we use experts to resolve this complex matter whenever we end up in arbitrations, because it is heavily contested. In certain contracts, when floats are purchased upfront, everything becomes critical and every delay might end up concurrent. So this is my experience on float. Probably industry experts could better answer this. This complexity still prevails. As on date, I am facing in every project. Majority of the project, the main concept generally agreed is the first come first serve basis, we call it. So whoever uses the float first, they take it for free. And then the project becomes, we call it as near critical in construction. Normally what the planner does is, the critical, whenever the float is 0, we call it as critical path. Such activities are in critical path. So normally what we do is, we take a 90 days chart, the float less than or equal to 90 days, and we keep watch on that item. We will be generally vigilant, because 90 days in construction project, it will just go off. So it will make, we call it as a near critical. Sometimes we see in many construction contracts, so in such events, if employer has delayed such non-critical activities and made it critical, these concepts come in: who has purchased the float, who becomes the owner of the float, whether it can be shared or not, and it creates much complexity to the concurrency analysis. This is my experience with the float, but I don't have an answer yet on how to really resolve this. Yeah.
Thank you, Mr. Lakshmanan. We are at the end of our session, unfortunately. It would be great if
Adarsh, your mic is probably off.
Can you hear me?
Yeah, we can hear you.
Yeah. Thank you, everyone. Thank you for your time. We've reached the end of the webinar. Unfortunately, there are several questions which will remain unanswered. We would be happy to take on some of these questions. A lot of these questions are directed to the likes of Rohit, Shourav, and Justice Sikri. And I'm sure you would love to hear their views on some of these questions. But I must thank all the panelists. They have provided invaluable inputs. Their time has been so useful in understanding a lot of these concepts, which are still a little strange to Indian law. Thank you, everyone. And we hope we can constitute another one of these webinars, and see you at some other session of the Paris Arbitration Week.
Thank you, everyone. Thank you.
Thank you. Thank you, everyone.
Thank you. Thank you, everyone.